So the Terrorism Protection of Premises Act treats places of worship slightly differently to other use cases or other sites that are in scope. These are the 4 questions that I am regularly asked by faith leaders and that I'd love to clarify in these videos. There's a lot of faith leaders that think they may have an exemption from the legislation. Unfortunately, that's not the case. What they do have is similar to schools, regardless of whether they can expect 800 people or more on site, they still are classed as being in the standard tier, obviously provided that they have 200 people or more on site from time to time. They will always be classed as a standard tier site and only have to put in place public protection procedures as opposed to public protection measures. So yeah, with heritage sites, there is a nuance. Clearly, a lot of places of worship may be heritage sites. If they are a place of worship, then they will only ever be in the standard tier, obviously provided they hit that 200 person threshold. However, if they are a heritage site and they are not a place of worship and they fall in the enhanced tier, i.e. they can expect 800 people or more on site, they may need to put in place public protection measures. Now, those measures may be physical security in nature, and given that they are heritage sites, the planning permission cycles for those can be extended. Therefore, we would strongly suggest heritage sites start looking at this as soon as possible, as they've only got till April 2027 to put in place these public protection measures. Where we consider voluntary run organisations, specifically with places of worship, what they need to put in place is public protection procedures. Regardless of whether they are salaried or a volunteer, those individuals must know or be able to show that they understand the plan and that they are able to implement it. In terms of a training regime, volunteers are, for all intents and purposes, treated like staff, provided they will be involved or could conceivably be involved in implementing one of the public protection procedures. If they're never going to be involved in doing that, then there's no need to train them or to teach them about the plans. But if they are clearly integral into implementing those plans, then regardless of whether volunteer or staff, they do need to be trained on the public protection procedures. So for places of worship specifically, this is a nuance in the legislation. Fundamentally, what the statutory guidance states is if an event is part of the normal running of the site, then it doesn't sit as a standalone qualifying event. So in the examples of place of worship, if you're regularly holding weddings on that site, that would be seen as normal running and not a standalone qualifying event. And you should always factor in the numbers of people that you'd expect to see at a wedding, for example, when you're trying to determine what's reasonable to find, or in terms of numbers of people, what's reasonable to find on your site from time to time. If, however, you have a site that is being taken over purely for an event that's not the normal running, so an art gallery that's going to hold a music event because it's a big space, and that's been taken over by another organisation, not normally the organisation that owns the site or runs the site, that would be seen as a standalone event because it's not in the normal running of the site and it's effectively being controlled by another organisation. Yeah, we've heard from lots of faith leaders that they're worried about the cost of implementing or ensuring compliance with Martyn's Law. We'd like to reassure that the whole legislation was built and written to ensure that the burden was as low as possible, and fundamentally it all hinges on the term reasonably practicable. So for whatever site that we're talking about, whether it be places of worship or anywhere else, they should only be putting in place public protection procedures so far as is reasonably practicable. Now, clearly, understanding what that is or being able to qualify what is reasonably practicable can be difficult. That's why we've built Prova Risk, so that we can help people understand what that is. Our technology is built to be extremely cost effective and user friendly, so people do not have to worry about a huge cost burden. If you want to get started on your compliance journey, head over to provarisk.co.uk, click the Get Started button and start your compliance journey with Prova Risk.